Why did they leave? Yeah. Your Honor, we've got two witnesses that have been subpoenaed, Gary Antrican with the Public Defender's Office and Mr. Lyle Jones. Both are available, but they're a few minutes out and en route. And would we be allowed for a short recess to allow them to arrive? They were allowed to leave because they had other things to run and take care of real quick.
Your Honor, perhaps we could have a jury out as to the relevance of their proper testimony.
We're not going to close late as we did last night. We're going to break here after a little bit. Obviously, we're not going to finish today, but we'd like to get as much cooked in as we possibly can. But anyway, we're going to take a recess at this time. Please don't discuss the case, but we'll let you know it's time to come back. Step out of the jury.
Is he here? Your Honor, we have another witness that we could call instead. If
I just said call the next witness.
I'm sorry. I'm sorry. I didn't realize that there was actually another witness out there at this time.
You can step on out to the jury room, please. The state had a matter it wanted to take up the jury out.
Okay. This is Gary Antrican and Lyle Jones. Okay.
It was indicated that two of the witnesses are the public defender, Mr. Antrican, and the assistant public defender, Mr. Lyle Jones. I suggest that they don't have anything relevant to offer. I believe that what they're being offered for is the fact that originally Mr. Parsons was charged with some cases, and a couple of cases went straight to the grand jury. And that once he was indicted for that, it's my understanding, although I'm not a witness, but my understanding of the proffer of the testimony is that an assistant district attorney who's no longer with the staff indicated that because some of these cases had gone straight to the grand jury, that a new bond was required on Mr. Parsons, and this led to his arrest for the additional charges, and that Mr. Lyle Jones and perhaps Mr. Antrican were in the courthouse and witnessed some of this colloquy about the need to arrest Mr. Parsons. That's the only thing I have ever heard that they have any knowledge of concerning this case. Obviously, they're officers of the court, not fact witnesses, not expert witnesses. And if that's the nature of their testimony, I would object to it being irrelevant.
Your Honor, these witnesses' testimony goes straight to the bias and the heart of this case. They will testify that there was, in fact, a conspiracy that they are aware of, plotted into going to a grand jury and having me indicted on bogus charges where there was absolutely no proof whatsoever as a result of retaliation, because I went to the grand jury to have Mr. Neil Odom indicted when he, in fact, at the probable cause hearing, had exculpatory evidence. He actually provided to me after the fact this exculpatory evidence, and he stood there in the courtroom as his witnesses testified contrary to their original statements. And because he had testimony from me and my wife supporting that we were shot at, we were the victims, we had the people shoot at us, killing our dog, which created the whole scenario. And the fact that he understood a citizen's arrest is legal and was being affected, and these people evaded that arrest, all of this culminates to the fact that when I went to the grand jury because I tried to get these people arrested and filing a complaint, but the clerk's office said they can't take the complaint. They denied me due process. Goes to the heart of the matter. When the district attorney goes to a grand jury to try to drum up bogus charges in order to, as it was quoted, teach me a lesson, have my bond increased, have me locked back up, to teach me a lesson, how dare I? And in the jury room, while I'm there with the jury foreman, and I get to Neil Odom, hold on, Mr. Parsons, I've got a question I've got to ask. Walks to the door, and there's none other than Mike Donovan standing at the door. And he tells him, hey, he's trying to get your assistant indicted. All right, keeps him there. He comes back in, I finish. I'm trying to get charges brought up against Barry Laxton for shooting at me, committing a felony, aggravated assault, reckless endangerment, felony cruelty to an animal, and felony killing of a wolf, endangered species, mens rea. Number 2, Mr. Nick King, who assisted the perpetration of these crimes. He facilitated. He was a player, an actor, and a facilitator. Mr. Neil Odom, of course. Also, I was proceeding after Officer Walls, who had my testimony, who failed to follow the law in his duty to arrest these people and to assist me with a citizen's arrest. This took over an hour, and when I came out, I was met by an Officer Fletcher, who informed me that this charge had just occurred moments earlier, and he had a blank sheet of paper. No capias, no arrest warrant, nothing. Didn't know anything about the charge. And during that hour-long presentation to the grand jury, after the fact, after the jury foreman went and spoke to the DA, which is highly irregular, illegal as a matter of fact, then the fact is that I was falsely charged. And there were 2 witnesses, not one, but 2 witnesses of the public defender's office, the district public defender's assistants, employees of the state, who overheard this conspiracy, informed their boss, and then at a later date, when I requested legal counsel specifically through the public defender's office in this courtroom, Mr. Gary Anderkin, the elected district public defender, told the court that he had a conflict of interest, had an ex parte meeting, then later consulted with me and said, Mr. Parsons, this is why I can't do it, because I don't want to have to cross-examine my own attorney. But now, if you'll waive that, I can represent you. Otherwise, if you're going to call him, you need to get somebody else or handle it yourself. And that's what these folks will testify to, that this whole charge against me is a conspiracy to take Mike Parsons out of the picture. That is material to this case. These charges are bogus, and once they testify, we're going to move that those charges be dropped immediately.
Your Honor, I'm astounded. This is a change, and I have to change my position. If he has the district public defender here to say that there was a conspiracy and that they're bogus charges, then I think at least we need to have an out-of-court hearing on that, Your Honor. And then I'll take the position that I'll need to take as to relevance.
I also have an audio recording of my conversation with Mr. Anderkin to support everything I've just told you. I also have an audio recording of all the conversations related to this with the various people. Be glad to provide it to Your Honor. This is a crime that needs to be investigated. I've gone to the FBI. I've provided them with documents. Don't know what they're doing with it. I've actually filed a federal lawsuit, which Your Honor is aware of, against the district attorney and Neil Odom, citing that conspiracy. That's why I moved this court to move this out of the district, because of the... You weren't aware that I filed a federal lawsuit against Mike Donovan?
No, sir.
I filed a motion in this court and argued that before this court, Your Honor. I'm sorry if Your Honor, I argued that in this court. There's a motion on file.
Yes, you argued a motion the first day of trial about a lawsuit that you filed, but the lawsuit that was made in exhibit does not list Mike Donovan or Neil Oldham.
No, sir, this was back 2 weeks ago when you recall that motion? Motion to transfer venue is based on a federal civil rights lawsuit against Mike Donovan and Neil Oldham. I reassert that motion now if Your Honor would like to reassess the nature of this, the public defender, the district attorney being an employee of Mike Donovan creates a situation where there could be undue influence, where normally the Code of Ethics, when the district attorney general sees that there are elements that don't support the charge, where he has an obligation to dismiss the charge, is what the Code of Ethics say, he might be under undue influence to go ahead and prosecute regardless of that. And that was the basis for the motion for change of venue.
Where are your witnesses? Where are the witnesses?
Judge, I understand that Mr. Jones should be here shortly, in about 5 minutes, and that Mr. Anderkin is coming from Somerville.
We take a 5-minute break. Stand recess.
All rise. Circuit Court is now in recess.
Consider, but I don't remember what he said. He said, I may have to reconsider what I've just objected to.
So what about, did they ask about Fletcher coming in? They want to know why he's coming in to testify?
They haven't asked.
No, I'm hoping he lets it go a little bit further so I can get Fletcher into like a...
No ask.
If he asks you what you ask him, just tell him that you're going to ask him about my arrest.
That's
Don't-
all.
Yeah, don't
All
tell
I'm-
him, don't tell him about what you're
No.
Because this is going to go on till Monday.
Oh, yeah.
Yeah, he's already said it's not, unless,
Oh, really?
yeah,
Hopefully.
he said we're not finishing tonight.
No kidding.
That's what he just said a while ago.
Oh, man.
I didn't catch that.
That's what Chip told me. I said, what's happening? He said, it's not, I said, I called and made arrangements, I don't have to be where I had to be.
I think this now becomes a hot potato the judge doesn't want to get rid of, because he probably sees the look on some of the jurors' face that they're not buying this load of BS. And instead of the judge sending it to a jury and a jury quitting me, well, let's just pass the ball off to Shelby County.
Why would that happen? How could that happen?
Because he asked for venue change.
I filed a change of venue and argued it 2 weeks ago, and I told the judge the
It's too
basis.
late now. Oh, I see. But now he's going to grant
The
it?
judge acts like he never heard about the change of venue, or the fact that in the change of venue I filed a federal civil rights lawsuit against Neil Oldham and Mike Donovan back in July.
But who brought it up at this moment?
I pointed out that my next two witnesses, the district public
So it came up
defender,
Yeah.
secondary to you.
they're
bringing it up to that.
challenging my,
Right, and the
they're
VA
challenging
said,
my
I don't
witness.
see why they need to be here. So that's when he said, this is why they need to be here.
So it just came up in the course of
Right.
Yeah, I've been charged bogusly because it's retribution.
The judge is saying he didn't even know they were at it.
Said he didn't know that I filed a federal civil rights lawsuit against Donovan and Neil Oldham. And apparently he fired Neil Oldham. He said a former assistant DA. So that means that Neil Oldham's no longer working for the DA.
What did he say about your need to bring the policeman in?
They didn't even get to
Didn't
that.
get to that. I was hoping, because when I saw Fletcher walk out, I said, right when he called back, I said, Your Honor, we just got a witness here that we can call right now. And I had that little grin on my face, and I think he knew, something's, because I haven't grinned the whole time I've
The
been
question
here.
is, yeah, you don't want to get cocky now. Okay, you don't want to get cocky now. You want to just go steady, slow. You know all that.
Do you have that information sheet? Because I'll ask him today for it.
And he'll say, what's that relevant?
So maybe you'll get him in.
Stick around, you'll see.
Maybe you'll get him in before he...
I know why it's relevant.
I want to.
Why is that relevant?
So he may...
I'm Bernie.
John Sayota.
John,
Nice to meet you, Bernie. Is it Bernie?
Bernie, yes.
Common sense means
Common sense.
common sense.
It's good. See, we're bookends, right?
We are, no. Look, you guys are foundational rocks. You got common sense to galore. You can understand nature. Most of these people are just oblivious. I hope I'm wrong, but it just seems like.
Well, but there's awakening happening.
And your approach with that might be that you know that inside of each of them, there is a part of them that understands what's really going on. You need to access that.
I had checked this quote. I don't know if this can ever come out. Maybe in your closing remarks or anything. I just had a friend who's in tax court down in Louisiana. He's been talking to the IRS attorney for hours and hours and hours. Yeah, no, a friend of mine. Anyway, so after the first day in tax court, they were having dinner and he was showing them evidence and everything. And this guy says, "I've never seen this before. I have never seen this in the code before." And it's blatant, shows that citizens living and working in the United States are not liable for the income tax. I mean, it's right there in the code. All they have to do is apply the code correctly.
Citizens or foreign nationals?
No, United States citizens living and working in the United States have no income tax liability, federal income tax liability. The code states this.
That's been argued before, and people have lost.
Well, it doesn't, but the code.
It's in the code.
The code.
And so the investigator.
This information, the way it's being presented now, this information has never been presented before. But anyway, so what he said to him, the United States, the IRS attorney said, well, you know, he says, I feel foolish. I've made an error, you know, why I don't know this.
So you won this guy over? No.
Well, we're working on it. But anyway, so they were in this discussion, and the guy said something about making an error.
Mother-in-law.
You know, an honest man making. And Gary said to them, check this out. Gary said to the IRS agent, he said, you know, honest men can make errors. He said, but then they have a choice. They either correct the error or they can no longer be honest men.
Honest men can what? Correct you?
Honest men can make errors. However, once they're made aware of the error, they have a choice to either correct the error or they can no longer call themselves honest men. Isn't that great?
Well said.
Yes.
Well
So
said.
if you can somehow get that in your closing remarks.
Pat, were you in the courtroom when just what happened?
No.
Why not?
I had gone home to
5 minutes is
Okay.
Take care of the puppies.
because I didn't go home at lunch.
Good girl. They're okay?
They're fine.
So go back in.
I guess it's not ready yet. I'm sorry.
Heater up on. When we talk about questioning,
For who?
for me,
Okay, got it.
when you go call me,
Is this it?
yeah, well, I say,
I'm going to call Fletcher next. Is Fletcher here? Where's he at? Go tell him to fix the collar.
well, he's in that room. Bailiff had to call me.
Okay.
He's in that room.
Okay, I'll come. Okay. Smile at him when he walks by. Say, hey, y'all have a good day.
Man, it's gonna blow up. It's gonna be good.
You want me to call you first, or you rather me call Fletcher?
I think I need to ambush him first.
How you going to do it?
You're gonna do it. You're gonna ask him.
Okay, so what are you gonna do? Call you first.
No, you come on, call him first. Ambush him, then you'll ask me about it. You say, well, how did you? He'll say, well, you didn't. This is it right here. I'll let you have it. That's what you'll ask me. Like, didn't I give you that piece of paper to check out that witness?
You argued that much. Remember, I gave them to you. You didn't give me that one back. It's in the file. It was filed. It was a motion to transfer venue.
Yeah, I argued it.
Yeah, I know. And
I recorded. I got the recording.
Okay,
Play it.
Hey, can you play it today?
The recording?
Because I
It'd
remember
take me a while if they'll
when
give
I
me time to
heard
look it up.
Al.
After this witness, who would you call?
There's an officer here. Just take 2 seconds. Jeff Fletcher, he was the arresting officer.
I quashed the subpoena on that officer.
Sir?
I quash a subpoena for that officer. Who would be the next?
No, there was a different subpoena.
No, sir. I quashed the subpoena for the appearance of that witness.
That was earlier today?
Yes, sir.
Yes, sir. There was one just filed moments ago. He's back on a separate subpoena. Different, it has nothing to do with the video.
I quashed the subpoena for that officer.
There's a
Who
different...
would be the next witness after that?
Your Honor, I'm entitled to call a witness relating to the arrest.
I've already had a hearing on it, Mr. Parsons.
Not relating to the arrest, Your Honor. That was relating to a video. That was only related to him putting a video into...
A video of the arrest, Your Honor.
Right. That was related to a video. His attorney argued about a video.
Mr. Parsons, I've already ruled on that. You're talking about the arrest in July of 2009, or 8, I guess it was. Is that
Correct. Yes.
Some 10 months after the event.
We've had arresting officers today testify on the stand. We've questioned them about the arrest. There's no...
That's equally irrelevant, Your Honor.
You've asked about officers on the day of the event, not 10 months later.
It will show a bias and a relevance to my defense, Your Honor, and I must request that... I've only got 2 questions for the man. Just...
I've already ruled with regard to that incident.
No, sir, Your Honor.
2010.
Your Honor ruled about the video and not the officer. The questions I've got have nothing to do with the video.
So Mr. Jones would like to... You're looking at
Huh? Somebody took the hand.
You solemnly swear testimony given this cause to be the truth? Yes, sir.
Are we going to bring the jury in?
Well, no, so for the benefit of the record, this is a jury out hearing. The state's made objection to this witness testifying about the things that at least the state thinks this witness is going to testify. And if you want to make a jury out hearing, give me an opportunity to rule with regard to the state's objection.
What does that mean?
That means he's going to hear, they're going to bring it out before he makes a ruling whether or not they can be heard as
Okay.
witnesses.
Please state your name for the record.
I'm Lyle Jones.
Lyle Jones, please state where you're employed.
I work for the state of Tennessee in the District Public Defender's Office.
Please state your capacity.
I'm an attorney on the staff of the District Public Defender.
And Mr. Jones, you work in and out of the Tipton County court system.
Yes, I do.
On or about July the 8th, 2008, the day the grand jury was in session, were you in the courthouse on that day?
I was I'm sure I was. If it was on a Tuesday, I'm here for General Sessions Court just about every Tuesday.
And that day, did you have an opportunity to see the District Attorney Mike Donovan and his assistant Neil Oldham?
Yes, I did.
Was that in the break room in some part of the courtroom behind the actual courtroom?
Well, I saw them a couple of times. I think what you're asking about was I back behind the courtroom?
Is that where you saw them at one point?
I did see them at one point.
Okay. And during that time, is it true that you overheard them having a conversation relating to me?
I did.
And at that time, did you overhear them talking about having me rearrested, having my bond increased, and having me charged with additional charges?
What I heard, and I don't remember exact words, but I'm going to give you the flavor, the context, the impression I got, if that's all right. What I heard was them talking regarding you and aggravated kidnapping. Now, I haven't seen your indictment, but I'm in aggravated kidnapping, and to the fact that you would be taken into custody because you hadn't made bond on aggravated kidnapping because your charges below were different.
And
yeah, they didn't say that they were different. It was like that you would be taken into custody because you hadn't made bond for an aggravated kidnapping. And I just filled in the blank because if I remember right, your preliminary hearing wasn't about an aggravated kidnapping.
And was the comment made by either Neil Oldham or District Attorney Mike Donovan that we'll take care of him, we'll get rid of him, we'll do something to him as a result of me going to the grand jury and seeking an indictment against Neil Odom. When the conversation, was it ever mentioned that I was in the grand jury seeking an indictment of Neil Odom prior to that conversation? Was there anything?
I didn't hear that conversation, but I heard that you'd been into the grand jury that day, yes.
So you're testifying in court that you didn't hear Mike Dunament or Neil Odom say anything about me in the courtroom or in the grand jury seeking an indictment for Neil Odom?
No, I heard several other people that day, but
Discussing that?
yes,
Prior to hearing them back in the coffee break room?
yes, sir. Or the hallway behind the courtrooms.
Okay. Was there another person that was with you at this time? Another member of the public defender's office?
I'm pretty certain that I was talking to Investigator Huggins at the time.
And he overheard the same conversation?
He would have overheard anything that I heard back there, yes, sir.
Okay. And did you and both Mr. Huggins report this information that you had to your boss, Gary Antrican?
I went and had a discussion about this with Gary Antrican. I don't recall that Investigator Huggins was there, but I did discuss this with Mr. Antrican.
And your reason for discussing that with him was?
I understood that there might be a possible conflict arise from having overheard something that when I discussed it with him, he said, well, you might be a witness and I think we have a conflict. So we discussed it more fully from that basis.
And the reason you might be a witness is because there was the thought or the view or the opinion or the fact that Mike Dunavant, the district attorney, and his assistant Neil Odom had in effect conspired to have me falsely charged and arrested and have my bond increased because I had gone to the grand jury to seek an indictment against his assistant Neil Odom.
I can't answer that. There was too many parts of it. Could you break that down?
Yes, sir.
Ask me what you're
Yes, sir.
asking?
The reason you felt compelled to tell your boss was because you thought there might be something wrong with this conversation that you had.
I was engaging in idle chit-chat with my boss, and then it was when it came up that, well, there might be a conflict if should we be appointed to represent you. I didn't go to him and say, look, they're trying to, there's something wrong with what's going on here. I told him, well, that's what I heard. I heard them talking about that he hadn't made bond on the aggravated kidnapping.
Did you ever make the comment to anyone that they're railroading this man at any time, in or out of court?
Not that I recall. I do have personal opinions, but I don't recall discussing it at that depth. I'm not from here. That's not something I'd share with how I feel about ongoing things. That's not something I'd be sharing around. I haven't been here long enough for that.
And when your conversation was with your boss, did he have the opinion that because... Did he relate his opinion to you when you gave him that information?
That I overheard them talking about getting your bond set on aggravated kidnapping?
Yes, because in the course of events, if there's additional charges, it's common for a person to possibly be rearrested and their bond increase. That's common. Apparently, you went to your boss to tell him about this because there was something uncommon about it. Is that not true?
I didn't go to him to tell him about it. We were engaging in I don't know, at the end of the workday stuff, hey, this is what I heard, this is what happened, how things go today, and that's when it came up and we started talking about it. I'm sorry, that didn't answer your question. What was the question?
In the course of events, the district attorney would consult with his assistants about having someone have an additional bond if the charges were brought to a higher level, have them arrested, brought in additional bond increased. There's nothing strange about that, is there?
Not that I'm aware of. I mean, when the grand jury indicts, I think the judge sets the bond.
Mm-hmm.
The judge over here sets the bond.
But you're aware
that have been indicted.
Right, but you're aware, prior to this conversation that you overheard, you're aware that several people in the court had talked about me being there to seek an indictment against Neil Odom.
Absolutely, I heard that from a dozen, if I heard it from one.
So it was widely known. Possibly Mike Dunavant and Neil Odom knew about it.
I would assume that if I knew about it, that pretty much everybody in the court knew about it.
And is that the reason you contacted your boss, Gary Antrican, and informed him, because it potentially could be foul play?
I talked to my boss at the end of the day because we heard it, and that was just what came up at the end of the the date. He's the one that pointed out, well, we could have a conflict in such a scenario
Why would there be a conflict?
if we were appointed to represent you.
But how is there a conflict?
Well, the conflict is obvious in that Mr. Parsons has subpoenaed him as a witness. So
No,
that's-
sir, that was after the fact. The conflict arises when, if there's a belief that the district attorney has conspired to falsely charge someone, that would be the conflict, because if the district attorney just increases a bond and has someone arrested, gets an indictment, then that's the everyday course of business. It's no big deal. No reason for you to be recused. No reason for you to tell your boss. No reason for your boss to tell me it's a conflict of interest, right? No reason for a conflict of interest at all if it's everyday course of events. But
I'm not sure what you're asking.
well, how is it a conflict of interest for you to,
Well,
the office to represent me?
I think the thought process was, and I'm assuming that I have your permission to disclose anything that we talked about with me and my boss as it related, because I understand that we were appointed to represent you for a while. Right, we were appointed to represent you for a while. Weren't we appointed? Yes, sir. And I'm assuming that I have your permission to discuss whatever Mr. Anderkin and I spoke regarding.
At that time, you had not been appointed. That was shortly after probable cause hearing. That conversation with your boss occurred July the 8th or thereafter, 2008, and the appointment for the DA occurred in January of 2009, briefly.
Yes, I'm just asking out of abundance of caution before anything that my boss and I discussed, that before I disclose it onto the record, that I have your permission to do so.
There was no relationship at that time, so there's no need to ask for that request. Well, you weren't working for me.
It's your privilege. I mean, the privilege doesn't belong to me. I'm just asking you if you understand that you're waiving that privilege by asking me to talk about conversations that I had.
Conversations that you had with your boss?
Yes, sir.
Certainly, I have had no privilege because there was no contractual relationship. None existed.
Look at it as the nature of a quitclaim deed. If there is a privilege, are you waiving any privilege that might exist?
I'm not waiving anything because I don't feel that I had anything. I'm not waiving anything in this courtroom.
All right, the court's heard enough. The objection by the state is sustained with regard to the grand jury proceeding. Whatever occurred in July of 2008, the court finds it to be irrelevant to the issues that this jury has to decide. The grand jury returns an indictment or doesn't return an indictment. I take it from what the defendant has stated here on the record that he approached the grand jury, attempted to get other people indicted. The grand jury apparently failed to indict those people. That's not for this jury's consideration. What is for this jury's consideration is that the grand jury did return an indictment against the defendant, Mr. Parsons. The jury will have to determine whether the state will carry its burden, prove beyond a reasonable doubt that the defendant committed any crime, and if so, what crime. And to put in front of the grand jury what may have been presented to the put in front of this jury what may have been presented to the grand jury, what may have been transpired outside the grand jury door in July of 2008, some 10 months after the events alleged in this indictment, would not only fuse issues, give irrelevant things for this jury to decide, but the state objects and the court's going to sustain the objection. The state have any benefit of the record that's been made? Any questions to this?
No, sir. The state has no questions of Mr. Jones.
All right, you're free to leave. Thank you.
Has Your Honor had an opportunity to review the court record on October 9th, 2009, specifically the motion for change of venue?
On what day?
October the 9th, 2009.
We had a motion.
It was mailed.
Motion for change of venue?
It was mailed, but you didn't argue until November like the 2nd or something.
We argued it on November the 2nd. I think it was a filing date was October 9th, but it was argued on November the 2nd, Your Honor.
Yeah, there's a written order with regard to the findings. for the motions that were heard November the 2nd, to include the motion for change of venue. The court recalls being that the defendant moved to change venue based on media coverage in his allegation he's politically and legally active in Tipton County. You presented 3 affidavits on your own. With regard to pretrial publicity.
Does it mention the lawsuit, Your Honor?
The order doesn't.
No, not the order. The complaint, the filing, the motion.
Well, I don't believe it was brought to my attention. If there was a...
If it's in the motion, Your Honor, it's brought to your attention. It was read in open court, Your Honor. I read it.
Your Honor, if I might state the obvious, we're in the middle of the trial, and Mr. Parsons did not even exercise all of his peremptory challenges.
In any event, there was no difficulty in selecting a jury. The fact that if in fact the lawsuit was filed by the defendant against the DA and or any of his assistants would not be grounds for change of venue in any event.
It just seemed as though Your Honor was concerned about that prior moments
You said
ago.
I was aware of it. I was not aware of it.
Part of the record. Is it there contained within the motion, Your Honor?
I don't know, Mr. Parsons. I haven't looked back at your motion. I haven't looked back at your motion.
Okay.
You got my motion. You had my motion. Look at the record.
It's it'll be in the
No, it's a transfer.
let's see that stack of stuff here.
Actually, no, sir, it's not. The lawsuit itself is not attached to the motion. It's a motion for change of venue.
Is a citing of an identification and citing of the lawsuit without an attachment in it?
And the motion contains some internet news type articles, some photograph looks like to be from the Covington Leader, affidavit of Michael Parsons in support of the motion. Again,
Does the affidavit contain the words that I filed a federal civil rights lawsuit against Mike Dunham, the district attorney, and Neil Odom, his assistant?
It contains words that concern what you just had Mr. Jones testify about. Yes, it does say you filed a civil rights lawsuit against the district attorney general Mike Dunham for conspiracy. The lawsuit was not attached, and that, in fact, was not brought to my attention as one of the facts.
The fact that's cited in the attachment, Your Honor, is citing.
Ruling of the motion, but in any event, it would not have changed my ruling with regard to the change of venue. The change of venue was denied. We had no trouble selecting a jury. It was done before lunch.
What is the jury selection?
And who would be your next witness, please?
All right, call him next week.
Clark Washington.
Call your next witness.
Clark Chapman. Clark Chapman.
And who is this witness and what will they testify about?
He's the state's appointed private investigator.
Yes, so that's, it's, Your Honor, a part of what I know has been requested for his services is his perceived ability to detect truthfulness and untruthfulness in witnesses. And certainly the state would object to the private investigator testifying as to who is telling the truth in his professional opinion. I don't really know the relevance of what else, but I wouldn't be surprised if it's irrelevant based on the pattern already exhibited by Mr. Parsons. And I would just hate for something incredibly irrelevant and inflammatory and not appropriate for a jury to come out.
When the court appoints a private investigator, it's generally to do investigation, not to become a witness in the lawsuit, which I think really is not proper, to be quite frank about it. So you need to tell me why. I know you referred to the investigator as not even working for you, which was...
No, sir. I've never said it.
Well, you said he was working for the state. not paid for by you.
He's paid for by the state,
Yes,
yes.
paid for, but you've left that impression with the jury when in fact he was supposedly going to be working with you. That's what he was appointed for.
According to the way I read the order, he is ordered to investigate, and he is working for the state, and I recited what I understood from that order, that he is paid by the state, hired by the state, trying to identify and investigate.
No, so he's not working for the state, he's working for you. I'd like to know what the investigator, if you plan on calling an investigator, what he anticipates testifying about.
He'll provide evidence that would impeach the credibility of Nick King, as well as show biasness in the case.
What do you mean by show bias in the case?
That's for him to, I mean, that's what he's here to testify
That a
for.
witness has told him something different for impeachment purposes, court allowed to be called for that purpose.
Yes.
Call the witness, please.
Chapman?
See if the jury is ready. If they are, let's put it in place.
Your Honor, as I recall, the only thing that Mr. King was asked about in any conversation with the private investigator was, do you recall the conversation with the investigator and you're saying such and such, to which my memory of Mr. King's response was, I don't recall, in which case I don't know what's being impeached.
All right, we'll have the jury out again.
He
Come
actually-
right up here, please. No, wait, hold over with the jury, please. Jury out, please.
What is wrong with the jury being here?
She wants the first year jury asking. He wants the first year jury asking.
Why?
Because to see if it's.
Why is he doing this to all my
Jury out
witnesses?
here to try to find out the scope of your testimony, for reported testimony.
Your Honor, can I ask why you're denying the jury to hear all of my witnesses? You've not done this to any of the prosecution's witnesses.
The other side objected to, we heard is objecting to things. I can't rule on it unless I know what the witness anticipates being asked and what he anticipates saying. So that's why I'm doing it.
His objection is not well founded.
Well, that's for me to decide, Mr. Parsons. Have a seat, please.
State your name for the record, please.
Clark Chapman,
And your occupation, Mr. Chapman.
private investigator.
And where is that at?
The company is in Memphis,
The name of the company?
Eyewitness Investigations.
And how long have you been with this company?
I've owned this for about 11 years.
And what kind of investigations do you do?
Legal matters, usually criminal cases.
Okay. Can you go into the types of cases that you get involved in criminal cases? Are they drug charges or murders or major stuff, small stuff?
A lot of murder investigations, yes, sir.
Okay. Serious charges.
Mainly, yes, sir. Yes, sir.
And were you employed to work on this case of Parsons versus, or Tennessee versus Parsons?
Yes.
And employed by the state of Tennessee?
Appointed, yes, sir, through the court.
Through the court, okay. But you were appointed to assist the defense in this case, is that correct?
That's correct.
Okay. Now, do you have any loyalty or any requirement that if you find something that is damaging to the defense that you're not obligated to report that?
I just turn all my findings, reports over to,
Turn it all over?
yes, sir.
Right, okay. And when did you start on this case?
About September, 1st September.
And did you have an opportunity to speak to any of the state's witnesses involved in this case?
Yes, Nick King.
Nick King. And can you testify as to the content of the conversation?
Yes, sir.
Okay. Did Mr. Nick King respond to you? Did you ask him first about the dogs?
Yes, sir. I'm asking about the whole instance.
Did he give you an opinion about the dogs, whether he was afraid of them or knew them? Or
He just said, usually just shoo them away. That's what his statement was.
did he show you how or tell you how to shoot them away?
He didn't say.
Clapped his hands or anything?
I believe he did mention that.
Okay. Did he say anything else related to this case that might lead you to believe that he's not been totally honest in this court case?
As far as
His credibility?
his statements that he's made.
Statements that he's made or information that you've identified, his record,
Yes,
public
sir.
filings?
Yes, sir.
And what would that be?
As far as his statements, some of those things, what he said, what I understood was told in the preliminary hearing.
Okay. So you found inconsistencies in his statements
Yes, sir.
from what he said then to what he's saying now?
Yes, sir.
Okay. And could you recall any of those specific statements that you found inconsistencies on?
If we look at the notes, I don't know.
Okay. But those would be the things you would testify to today before the jury if they were brought back
That's
in?
correct.
Okay. And you were able to look into his past and do a background check, is that correct?
Very preliminary, just a few things. Didn't get
Right.
very deep at all.
Okay. Now, did you ask Mr. King about the citizen's arrest?
He mentioned in his statement that Mr. Parsons was making a citizen's arrest. He was trying to make a citizen's arrest.
And
Several times during that statement, he told me several
Did-
times.
did he say that he submitted to the citizen's arrest?
I don't know that he said that.
Did he give you an indication that he was in fear?
I'm going to be hard to answer that, I guess, with what he was in his statement there.
Did he say anything to you regarding Mr. Laxton as far as Mr. Laxton inquiring of him, did Mr. Laxton do the right thing?
There was some mention in the audio recording, I believe, of the 911 tape.
So you acquired 911 recordings, correct? Okay. And you reviewed those 911 recordings, correct?
That's correct.
Was there anything on the 911 recordings that you found to be inconsistent with the transcripts at the probable cause hearing?
Yeah, there were points in there, yes, sir.
Okay. Things that would bring into question his credibility on the stand?
Yes.
Okay. Did he reveal to you any relationship with any members of the Tipton County Sheriff's Department? Friends, relatives?
He said, he said he was friends with Poncho. I think he said Poncho and them, whoever them were. He did
Poncho
say-
and who?
He did mention Poncho and them. I don't know who he referred to as other officers or what, but Poncho.
Okay. Okay. And if he had testified in this court that he knew Poncho but wasn't a friend and he didn't know any of the other officers, that would be inconsistent with his conversation with you.
Yes.
And you did further investigation regarding determining witnesses in the court, is that correct?
I'm sorry.
Did you do further evaluation to determine who the witnesses were?
Yes.
I'd like to present this to the... Could you please identify that sheet?
It's one of the juror sheets.
And what's the name on the sheet?
Debbie Hanks.
Debbie Hanks. And during the voir dire, if questions were asked, were anyone in the group related to any member of government in Tipton County, closely related to anyone at all, and if she said no, would she have answered correctly?
I don't believe so.
Who would she have been related to that would make that a false statement on her part?
One of the officers here, and
Where's that information sheet? And do you have an information sheet on who that officer is?
Jeffrey Fletcher.
And would you please state the age, the birth date, and the spouse of Jeffrey Fletcher so we know we've got the same Jeffrey Fletcher?
Be 2/4/69, date of birth.
And spouse? Is that Melinda?
Melanie.
Melody?
Melanie Fletcher.
And is in fact Jeff Fletcher the arresting officer under the charge of aggravated kidnapping?
Yes, sir.
And isn't it a fact that Jeff Fletcher's mother-in-law is sitting in the far right seat of the jury at this time?
I don't know that. I just know that this is the...
So if that person named on that sheet is in fact Jeff Fletcher's mother-in-law, and she's sitting on the jury right now, that would be in violation of the rules of court where she had took an oath to faithfully perform her duties, but yet she's a close personal relation, a mother-in-law of the arresting officer, and she failed to notify that court of that. Is that correct?
That's correct.
Isn't it a fact that there's also a civil suit pending against Mr. Jeff Fletcher by me at this time?
Yes, sir. We're understanding this.
Your Honor, I move for mistrial.
Yes, sir, stay there. First of all, if I could see the document that reference was made to, it looks like a jury questionnaire.
Yes, sir.
And I'd ask that for identification purposes that this juror questionnaire be made next numbered exhibit. And I ask to be passed back to the investigator. Now, where did you get that juror questionnaire?
Mr. Parsons,
And when did you get it?
today.
Okay. And are you aware that it's a public record, at least as far as the participants in a trial, that juror questionnaire? Are you aware what that...
As a public record?
Well, it's a public record, everybody involved in the case and evaluating the jury. Are you aware of that?
I didn't know if it was a public record or not.
In any event, is there any indication on that juror questionnaire presented to you about any relationship with law enforcement?
Yes, it is.
And what does it say?
Son-in-law.
Okay, what is the question and what is the answer?
Are you or any close family member related to anyone employed in law enforcement? She said yes. Answer yes.
Son-in-law.
Son-in-law.
And that would have been a juror questionnaire available to Mr. Parsons, who conducted his own voir dire of the potential jurors. Is that correct?
That's correct.
And when was it brought to your attention that Mr. Parsons knew about that son-in-law being Jeff Fletcher?
I brought that to his attention. He asked me to look at the situation and ran some reports. And
Why, when did he tell you to look at it?
Earlier today.
Just today?
Yes, sir.
Now, you heard, or were you in here during voir dire?
Yes, sir.
And are you aware that the questions were asked of all jurors, do you know, among other things, do you know the defendant Michael W. Parsons?
I don't know. Like I said, I wasn't in there, so I don't know what happened.
Well, is there anything inconsistent with the response of no, I do not know Mr. Parsons, and your investigation and the juror questionnaire? Is there any reason that you would have to suspect that one of these jurors sitting on the jury panel, 13, had any knowledge that Jeff Fletcher was involved in this case?
I don't know that.
Are you aware that Jeff Fletcher's name was never mentioned by either the state, since he's not a witness, nor even Mr. Parsons, who has tried to make him a witness?
I don't know. I haven't been any inside the court or any proceedings. I just don't know what's been said.
Well, you're aware that it's Mr. Parsons who has been hurting himself to get Mr. Fletcher before this same juror as a potential witness.
I'm aware that he was subpoenaed, yes, sir.
Even though Mr. Fletcher is not a witness at all to the crime.
Not that I know. Not that I know. I don't know if he was on the scene or not. I have no idea.
Okay. Are you aware of whether or not Mr. Parsons during voir dire followed up in any rudimentary or elementary or any kind of fashion which the questionnaire that was furnished to him on the response, my son-in-law is law enforcement?
Not that I know of. I wasn't here. I don't know. I wasn't involved in that process.
That's all I have about mine, Your Honor.
With regard to the other questions, do you have any questions this witness with regard to those?
No, so just argument on the other.
All right, thank you, sir.
I've got a few more questions to redirect. Mr. Chapman, how long ago did you get this information?
Probably 2 o'clock. 2 o'clock today.
2 o'clock today? And then there was another subpoena effected for Mr. Fletcher to come in?
Yes, sir, it was.
So if there was a motion this morning to quash a subpoena for Mr. Fletcher to bring in a videotape, that would have had nothing to do with this subpoena at all, correct?
Yes.
And it's not just any law enforcement officer, it's a man who has a lawsuit against him, and his mother-in-law is sitting on the jury. His mother-in-law was asked under direct questioning, is anybody on the jury directly related to anybody employed in the government in Tipton County? Now, the questionnaire doesn't say they're related to anybody in law enforcement in Tipton County. It just says law enforcement. That could be Shelby County, Fayette County, another part of the country. It doesn't specify. That was her opportunity to say, yes, Your Honor, I'm related to Jeff Fletcher. He's a sheriff's deputy right here in Tipton County. At that point, she would have been released.
You have any more questions this week?
Yes. Is it a fact that when you spoke with Nick King, he not only informed you that he knew Poncho, but he said...
I object to that being outside the scope of the cross-examination. It's improper redirect. I didn't ask any questions about that.
Did he not say that he also knows all these other guys, referring to the deputies?
Yes, sir. Yes, there was a Poncho and them, I believe it was, or something there. Yes, sir.
Right.
Others besides him.
So if he stood on the stand and testified that he didn't know any of the other officers, didn't hang around, didn't talk to him, that would not be a true statement. Thank you. Your Honor, I think the witness has proven that he will have the ability to impeach Mr. King's testimony, and I would ask that the jury be allowed to...
To say that at the time he didn't know any others other than Poncho. He's gotten to know several of them since.
Well, he testified that he doesn't know any of them now.
But in any event, the court's sustains the state's objection with regard to this witness testifying about his impression of credibility, whether there's conflict between what supposedly some witness told him and the transcript of the testimony at the preliminary hearing. And the witness was not in the courtroom during the testimony of witnesses, so he can't testify about, just as you asked the question about conflicts between what the witnesses have said and what they told him. If you want to ask fact-specific questions of this witness with regard to his conversation with Mr. King without the conclusion, the court would, of course, allow that.